7:32. We'll open up the meeting. The Zoning Board of Appeals of Haddam, Connecticut will hold a public hearing and meeting at the Haddam Town Hall, 21 Field Park Drive, Haddam, Connecticut, on Thursday, April 26th at 7:30 p.m. to act on the following items. Public hearing, an appeal of a cease and desist order issued to WFS Earth Materials, LLC, WFS, for violations of the following conditions of the Town of Haddam's Planning and Zoning Commission special permit issued on January 18, 2012. Number 5, hours of truck operations from 8 a.m. to 4:30 p.m. Monday through Friday, excluding legal holidays. Number 6, WFS shall record all truck traffic hauling earth materials from the site on a daily basis and shall be filed with the ZEO on a weekly basis. Such report shall include a copy of the pre-numbered invoice slips for each day as well as the data from the electronic counting device. And number 7, a surety bond in the amount of $80,000 shall be maintained by WFS to assure funds for restoration of the site. At this hearing, interested persons may appear and be heard and written communications received. Said appeal is on file and may be seen in the Land Use Office, Town Office Building, Haddam Zoning Board of Appeals. Tonight for members, we have Jen O'Neill. We have also Helen Reed, myself, Robin Munster, David Papalo. We've got Margot Chase Wells, and we have Tom Berchowski, and we also have Ken Went and Jim Puska. As for everybody being seated tonight, we have a full house tonight. We need 5. So, who wants to sit on for alternate then?
You have all 5 of the regular members.
Yeah. Oh, we have all members.
You don't need
members.
all
We don't need any
alternates.
alternates. Okay. So I guess the alternates can you can sit at the table, unless you just can't give any input. Okay. Thank you for showing me. Okay, so that's what we'll end up doing then for people listening to the appeal tonight. First, we'll hear from the WFS appeal, and then anybody who has any statements afterward can make statements to the board. Nothing can be made to the audience, everything has to be made to the board. And there will be no conversation back and forth. Everybody understand? Be nice and smooth. Okay. We're ready.
Well, good evening, Madam Chairwoman, members of the board, Madam Clerk, and Mr. Pushkin. For the record, my name is Chris Smith, and I am a land use attorney and a partner at the law firm of Shipley & Goodwin. And I appear before you this evening on behalf of WFS Earth Materials, LLC. I wasn't sure if Mr. Pushka was going to be doing a report relative to an investigation that might have been done.
No.
And I do have some questions for Mr. Pushka, but I'll just do what I have to do for the record. And having sat on a ZBA at one point in time myself, I'm going to be presenting some legal arguments which neither the board may find very interesting, nor the citizens in the audience, but I do have to create a record. And the first document that I would, oh, you know what I have to do first, I apologize, is I did send legal notices out. It's somewhat unusual when you take your own appeal that you have to send notices out to the abutters, but we did do that, and all the receipts are in here, a copy of the original letter, and then a list of the abutters.
Okay.
And copy that was sent to the letters I think were sent in already, but there's the certified mailing receipt. And this is a document that I've been filing. I think I filed it the last time I was here with one of the prior cease and desist orders before Mr. Pushka that was issued, and we've been to court, and the court has a few of these. I think you have a few of these in your record. And I'm not going to walk you through all these documents, but I would like to note that in Exhibit E, we did provide, there seems to be some confusion relative to the bond, but there was a $80,000 bond required at some point in time. I think it was with the 2006 approval. All that's in here in Exhibit E, and we have renewed that all the time, and the most recent renewal of that of that is dated March 2nd, and it runs from May to May, and that's what it's been doing. And I know in having conversations with the town attorney that there was some question on that, and I said, no, I believe the $80,000 bond is in place, and that's for restoration as the site as the earth materials are removed. There's a bond there to restore the site in case WFS were to walk from the property, and that was determined the amount back, I believe, in 2006 with Jeff Colbrook, and he was the planner. So that's in here, and I did put that in with the ED. Give that to the clerk. As you are probably aware, there are multiple pending appeals at the Superior Court in Middletown. We've had multiple decisions from a couple of different judges, Judge Bergdorf being one and Judge Abrams being the other. Two of the appeals are before the appellate court now, and they've been subject to a pre-argument conference with Judge Levine up in New Britain. And I am going to put into the record, and I spoke to the town attorney, Attorney Morisuti, about this, and I said what I would be, just giving a heads up as to what I would be doing this evening. And I do have copies of some of the various decisions, the first being from Judge Bergdorf. The town did bring a Section 8-12 action against WFS to shut WFS down. Section 8-12 is Connecticut zoning enforcement statute, and Judge Bergdorf denied that injunction relief, saying that there appeared to be a possibility that there was a valid non-conforming use on the property. We did litigate the initial appeal from the 2007 approval by the Planning and Zoning Commission, where they imposed a number of conditions, including a cap on the amount of material that could come off the site. And we challenged that, and ultimately Judge Abrams found that that was improper, that it could not be a cap. There's a non-conforming use on the Lentz portion of the property. The Waller has been, as the Lentz piece, subject to a special exception approval that happens every 2 years. And under your zoning regulations, the special exception is to be issued for 2 years. I'll get to that in a moment. So in 2007, the Commission imposed a number of conditions. We challenged those. Judge Abrams rendered a decision. I have a copy of that decision that's in here. Subsequent to the 2007 approval with these conditions that we challenged, WFS challenged, the Commission essentially revoked the special exception. They said, well, look, you're not in compliance with the 2007 conditions, so we're going to deny your renewal in 2009. And it was our position that we had appealed, you're going to hear the same argument, that we had appealed the 2007 approval with the improper conditions, and therefore we didn't have to comply with those improper conditions. And in effect, the town had tried to shut WFS down for not complying with those conditions, and that's the decision that Judge Bergdorf said no. They can finish their appeal. Judge Bergdorf, I'm not going to shut them down while they're litigating that particular approval. We did get a subsequent decision from Judge Abrams on the 2009 denial, and he said that it was improper. He ordered the Commission to issue the special exception. They just did that in January. However, contrary to the zoning regulations, which say you get it for 2 years, they issued it for 6 months, and we've appealed that, and that is in court in Middletown. Now, in 2007, after the Commission issued their decision with the improper conditions, in 2009 when they revoked it, and here we are, 2012, when they gave us a special exception that limited it to 6 months. Each time the ZEO, the Commission has had the ZEO issue a cease and desist order, and in those 2 prior occasions I appeared before the board making basically what is the same argument I'm going to be making this evening, and that is we have challenged the most recent special exception because it wasn't given to us, wasn't for 2 years as required by the zoning regulations, and quite frankly, as we believe Judge Abrams ordered it to be. So that is under appeal, and until that is resolved, we, just as before, we don't have to comply with the improper permit that has been issued. So in essence, that's my argument for this board this evening. I know it doesn't really get to any of the specific conditions, but as to the conditions, there's, and this was for a time period, the special exception, I believe in the order, says that it became effective on January 18th, and I think the order was issued on February 6th, so there was apparently like a three-week window there. And I don't know if Mr. Pushka made any investigations to see if the hours were being complied with. I don't know if there was any inquiry from the town, by anybody from the town, to WFS for the logbooks, but we have challenged this most recent issuance of this appeal, as I indicated. And the bond, I think there was just some confusion and a misunderstanding. That goes back long before Mr. Pushka started here with the town, and we do have that. That's been in place the whole time, and it was in that packet when I submitted it back. I think it was 08 might have been my first time here, or 07, I'm not quite sure. And each time that's been part of that packet. So I do have these various decisions, and in addition to our legal argument concerning whether we have to abide by the conditions of this improper permit, the Commission actually appealed Judge Abrams' decision concerning the 09 action by the Commission to revoke our permit. So that is actually on appeal at the appellate court. And until these issues are resolved, in Judge Bergdorf's decision, I don't think that we're in a position to have to be complying with a permit that hasn't been properly issued. So here's my legal argument. It's basically the same argument I made prior 2 times that I was here concerning the fact that we do have an appeal of the special exception. I do have Judge Bergdorf's decision that's dated, just want to make sure that I'm giving you the record. Judge Bergdorf's decision is dated January 29, 2010. We then have a subsequent decision from Judge Abrams. This was on the 07 permit that had the improper conditions that we challenged. That's dated November 22nd, 2010. We then have the order from the court. It was an order, one sheet, and then there was a follow-up memorandum of decision where Judge Abrams ordered the Commission, Planning and Zoning Commission, to issue us our special exception, which once again, under the town, the Commission, own regulations would run for 2 years, and we were only given it for 6 months. So I do have those various documents, and then I do have the 2 appeals from Judge Abrams' decisions that I can put into the record. Judge Abrams also basically denied or sustained our appeal from the cease and desist order that had been issued based upon the 09 revocation of the special exception. So back in 09, the Planning and Zoning Commission said, hey guys, WFS, you're not in compliance, we're denying you your special exception. And then Mr. Boudreau, the CEO, then CEO, issued a cease and desist order. We appealed that. I appeared in front of you making basically these same arguments. And then we went off to court, and then Judge Abrams said, well, look, what you did, Planning and Zoning Commission in 09, wasn't proper. You should have issued the special exception, and therefore the cease and desist order was basically invalid because it was based on the Commission's action. So almost the same type of scenario and the same arguments that I'm making again while we're litigating the appeal that is now pending in court in Middletown. So I do have those 2 appeals here. One is appellate court number AC 34215, and the other one is AC 34397. I'll put those into the record, and unless you have any questions for me, that's my presentation of the evening.
The bond, you said it was maintained, so the bond's been there and actually went back in and maintained it on March 2nd. You verified with the land use office that the bond was maintained?
No, we have to do that with travelers. If I can just, I'm sorry. And I think there's just been a misunderstanding. I know I had a conversation with the town attorney last time we were in the Brinkman court. And once again, Exhibit E has reference to the various approvals from the Commission, and one of them is indicating the bond requirement. And then I did have the bond in this prior submission, and we basically have to renew that with the town. But I mean, it's in effect. It started back in 06. It was, I guess I wasn't here, WFS obtained it in May of 06, and that was after the April of 06 approval. I think they had 2 months to post the bond, so they did it within a month. And then it's been maintained all the way through, and I just have, proof that it's a $400 premium for an $80,000 bond.
Okay.
And this is the same, it's just different dates. going through here with the time periods.
So it basically, land use office didn't realize that would be.
It's, right, and that's what I said, I think it was just a misunderstanding.
Okay,
So that's,
okay. Special permit, you stated that the judge ordered P and Z to issue a permit, or did he basically say, judge to issue judge would state to issue a permit, but he didn't state it had to be a 2-year permit, it had to be a permit? Because P and Z issued a special permit for only 6 months?
he said that they didn't, I'll read it to you here. He said, and I'm referring to the memorandum of decision from Judge Abrams dated January 30, 2012, and he indicates that he entered judgment, which was the Card decision, finding that the Planning and Zoning Commission's denial of the plaintiff's application for special permit was not supported by the substantial evidence. The court also ordered the town to issue plaintiff a special permit, and as a result, the court found in this matter that since the town's action denying the special permit was illegal, the cease and desist order, that's what I was saying, based on the plaintiff's lack of such permit that serves the basis of this action was likewise illegal. So the court said there was not substantial evidence in the record, which is the standard of review, to deny the special permit, so issue it. The special permit that we applied for, as provided by your regulations, is for 2 years.
But the P and Z has every right to issue a special permit, right? Am I right?
Under the regulations, you apply for a permit for 2 years, and it's either denied or it's granted. And
Jim?
Well, they decided to issue it for 6 months, and with the understanding that a few of these conditions have been violated on an ongoing basis, and they in good faith, offered that for 6 months to see that if you guys are going to come across and meet these, these conditions that were in the cease and desist order. And no one ever contacted us, no one ever brought us any receipts, none of them called us. The only calls we got were from illegal truck operation of ours, uncovered loads. I'm sure I don't have to say a lot, there's people right here that can testify tonight. So that's why the commission ordered that for 6 months. And they'd be more than glad to comply with you guys if you had met us halfway.
well, we have, apparently you haven't, Mr. Pushka, performed any investigations yourself. But we have been in negotiations, and that's the settlement process that Judge Levine is proceeding with the appellate appeals. And actually was indicated, I did indicate to the town that when this was happening back in January, that please issue it for 2 years, because that's what we're entitled to, and if you don't, I'm going to have to appeal it. And I certainly have been working with your town and your town attorney, and I told them that, we were going to have to take an appeal to protect ourselves because it was only issued for 6 months, and that's what I did.
Funny, you don't have to.
And also, I'm sorry.
I'm sorry, you don't have to have a copy of our permit zoning resolution with you. I
think it's section 18.
Yeah, I understand that you applied for the 2-year permit. My question is P and Z able to give you a special permit? From what I understand, they can, and I just want to look. No?
I think it's section 18.
Tom,
Actually,
do you have any?
that very issue, Madam Chairwoman, that's the issue on appeal in the
Yeah.
Middletown Court. That's what I'm saying. I'm making a legal argument to you tonight. It's the same legal argument that the judge in Middletown is going to be deciding. That's the basis of that appeal, is that we were improperly issued a 6-month permit in violation of Judge Abrams' order.
When would that decision come through, do you know?
Not sure. Not before the board acts on this evening. I would anticipate that with the briefing schedule, could be 4 or 5 months if it were expedited.
We've taken another
I just
couple of
wonder
billion
if P and Z
material action.
Please, no discussion from the audience, okay?
Has to issue a 2-year one. I mean, it's always been done, but does it say you have to, or you
Well, that's
may
what I'm
just-
questioning, and that's what I wanted to see, and
I don't remember, honestly.
I know we've talked about this on previous meetings, and I know it's come up, and I just don't have it in
Yeah,
there.
sometimes it's just that, that's the way it's always been done. But it doesn't mean that they absolutely have to. And I know there is a line in there about special permits, but I just don't have it in front of me.
Well, the excavation provision, once again, I think it's, don't hold me to, I'm pretty sure it's article or section 18. And it talks about a 2-year permit, and the 2-year permit has been issued ever since it was first issued for Mr. Flanagan's operation, going all the way back to 1986 for this property, and for this operation. And it has been a 2-year permit, and that's what the regulations provide for. That's the legal issue, once again, that's pending up in Middletown.
It seems to me that we're not here to decide that. We're here to decide, irrespective of whether it was a 6-month or it's going to turn out to be a 2-year permit. You did not follow the conditions set forth for the 6-month permit. And that's why we're here, is you issued a cease and desist based on that. So whatever the court outcome is, that's not really relevant to why we're here.
It will be relevant, it's relevant to us with our appeal to here, and then if there is a subsequent appeal from here to court, and then they would be consolidated, and just like with the 09, the commission does something, whether it's proper or not, and we didn't abide by what they did, they told us that we will revoke. They told WFS you don't have a permit anymore in 2009, even more so than what we're dealing with here. And then they issued a cease and desist order saying, look, we revoked your permit, we denied it, what are you operating for, period. And told them to stop, and that's what was denied, because on the merits of the appeal, we were found to, we prevailed on that, WFS prevailed on that particular issue, and then the cease and desist order.
Again, that's not why we're here.
Understood, but I'm just saying that that's the structure of what's happening.
If you had operated under the conditions that was given for the 6-month permit, we wouldn't be here today.
Arguably.
Even if it
I
had
don't
been a
know.
2-year permit, it didn't meet the conditions.
That's right. It doesn't matter.
Let's pretend it was a 2-year permit. Did they meet the conditions?
Well, maybe there would be compliance, there wasn't a 2-year permit, and that decision was appealed by the
I
planning
mean, so
commission.
WFS decided, since we only got a 6-month permit, we're not going to meet the conditions. If you had given us 2 years, we would meet the conditions.
That's a possibility. We were not granted
That's a
what
good
we were
decision.
told to, well, that's the legality of it, so.
Well, the P&G did follow the judge's order, they issued a permit, they just decided to issue it on a 6-month basis, and with that, that's why we have these conditions here. I understand number 7 does not take effect anymore, since your bond is there now, that we know
Yeah,
of.
nothing was brought to my attention about that bond, or nor have I heard anything from Attorney Marsudo about that bond either, and I've been in discussion with him. He hasn't mentioned it to me either.
Did you discuss it with?
I told
Attorney?
everybody at the last meeting a couple of weeks ago, Judge Levine, that there was a
But that's
bond.
what you just put into record.
Right, yeah, I mean, it's
So
not,
that's fine.
I don't see that as a major
Right.
issue. I mean, there is a
Right.
bond, I verbally conveyed it,
And
and
that's
I told the
fine.
client to get it to me, and I put it in the record.
Right.
It's not,
So it's really 5 to 6 that we're
Right.
looking at.
I don't think that's a critical issue.
So when this permit was issued, was there any legal wordage that said who needed to communicate with whom with regards to if these conditions were met? Like, is the failure of the communication of meeting these 2 criteria on WFS, on us, like who's supposed to be communicating?
They are supposed to deliver that information to the land use office.
Okay.
It states that right in the
Okay.
item there listed.
Okay.
I can't attest to whether they've been operating within the hours. I don't know if Mr. Pushka has made an investigation to determine that or not. But I understand that nothing has been turned in relative to any
No contact
information.
information, just phone calls.
So are you saying you think you're in compliance, or you're agreeing that you're not in compliance?
I am agreeing that we don't have to comply with the terms and conditions of the permit that we have appealed, just as we didn't comply with it the last time, starting in 2007, and when the town tried to shut WFS down at that point in time, Judge Bergdorf said, no, I'm gonna let you finish litigating those items, so that's
Why
what
did they
we are at
decide
this
not to
point.
comply?
Pardon me?
Why did they decide not to comply?
I think when we were issued a 6-month permit, and I was told that's what was gonna happen, I said, I think you should issue a 2-year permit. That's what your regulations provide for, and that's, Judge Abrams said to give us a
Doing it out of
special
spite
permit
or
we applied for. No, they're entitled to a 2-year permit, that's what the judge found. I mean, it was improperly revoked, these people, I mean,
Regardless.
we
Okay,
can,
regardless,
you've been on this committee,
you're
the
told
planning
to
and zoning for a
comply.
long time, I remember citing to you
You're
in
asked
the
to
transcripts.
comply on 3 issues, right? These are the 3 issues that we had concerns with, okay?
Well-
One of them, not a problem because the bond is in place. The other 2, they just decided not to comply?
We're not complying with it while it's under appeal, just as we haven't complied with, we've challenged the permit.
Okay.
That's the legal argument that, don't hear, but that's the legal argument that we presented.
Okay. Anybody have any other questions before we go to audience?
I just have a question. So in years past, 2 years, a 2-year permit was issued, correct, in the past?
Since 1986.
And were you in compliance during those 2-year periods?
I wasn't here, but I understand that it was. It wasn't until 2007, when Jason property owner got on the Planning and Zoning Commission, that there were these improper conditions that were imposed. That was appealed, and I don't know if I was retained at that point in time or during the 2009 application, which, once again, the commission said, well, look, you're not in compliance with the 07, which were these, just improper conditions. The judge found one of them to be illegal, and the other one concerning moving the permits around. He kind of left that for another day. And then it was based on WFS's alleged failure to comply with those conditions, with that permit, that they revoked the 09, and the judge said, wait a minute, he can't give improper conditions, and then based on that, an improper permit, based on that, revoke it, and then issue a cease and desist order and say they have to stop. So we have a permit again that we don't feel has been properly issued pursuant to the court's order. We've challenged it, and in the meantime, this is where we are. It's the exact same argument I made to you folks back in 2009, and we have Judge Abrams' decision saying, commission, not you, Planning and Zoning Commission was wrong in what they did, therefore the cease and desist order wasn't valid. And I'm making the same argument to you as the ZBA, and you're here in your quasi-official judicial capacity, but ultimately a judge decides this legal issue, and that's what I said. I feel bad, I'm making this, it's not like, okay, my client built something at 24 feet, and you're right to say 20 feet, and here we are, in a factual, I am making, basically, and that's what I wanted to say, and, it's the same legal argument that I made the last time, and the judge understood that, and that's why the judge said, okay, the Planning and Zoning Commission did, 09 was improper, and since that was improper, the cease and desist order was issued based on an improper action, and that's what we're arguing the same thing here tonight.
What would it take for WFS to decide to comply with items 5 and 6?
I think there would have to be compliance with the judge's order and not to have an appeal, I presume. The commission has challenged Judge Abrams' decision. That's
One
under
sentence,
appeal.
one sentence. What would it take to
You'd have
get
to
them
have-
to do 5 and 6?
What would it take to do 5
What would it
and
take for
6?
WFS to comply with items 5 and 6?
I'm not prepared to commit to that tonight. There's pending appeals at the appellate court that the
So
commission
basically you're
has
saying
challenged.
only if a judge says you have to comply.
If we prevail if the town loses on their appeal to the appellate court presumably will say that Judge Abrams' decision saying that our 09, the revocation, was improper, and we're entitled to have that reinstated pursuant to 2002, then I think my client would feel safe and secure that he has a valid permit at that point in time. Judge Abrams' decision has been challenged not by us, not by WFS, but it has been challenged by the Planning and Zoning Commission.
Basically what you're saying is, whatever decision comes out tonight, you're gonna continue doing what you're doing because it's an appeal and you're gonna wait for the judge, basically.
And we are pursuing, we are having discussions through Judge Levine up in New Britain.
May I ask when the 6-month permit expires?
Pardon?
When it was issued, 6-month permit?
I think it's effective January 18th.
Yes.
January 18th, so 6 months.
6 months. Thank you.
Yeah, 6 months.
Okay. Anything else anybody wants to ask before we move to comments from the audience?
I think it's fair to say we're basically beating a dead horse,
Yes.
and why waste a lot of time on this? We should get audience input maybe and just move forward because we're just gonna waste time.
Right. Yep.
I think that's what happened the last time I was here. Thank you.
I'd like to now open it up to the audience and for any comments. You can make your comments to the board if you like. Please state your name.
Robert Lentz, 57 Shirley Court. I can tell you that they have had a permit in the past for 1 year, so there is other options than 2-year permits. And other than that, the thing that they talk about, the number of trucks and the time they start, they are way over the permit allowed, and they start coming in before 7, and they always leave before 7:30. Not all of them, they start to leave.
Thank you.
I'd like to give you a synopsis
Your
of this
name,
whole thing.
please?
Mary Ann Gilman from 223 Cedar Lake Road.
Thank you.
In 2009, when we went to court to hear the little story going to Judge Bergdorf, and I had a little conversation with the town selectmen about what happened at that meeting, which is on tape if you ever care to see it. It wasn't presented properly by our attorney. Mr. Boudreau was not able to put on these people who have suffered from this hostile outfit who cares not for anyone in this town. So she never heard the story. She did hear the story that Mr. Anderson would lose 9 employees if they closed him down. So that was the hardship that they won that case at that time, but she didn't complete the case. Now we go on to Mr. Abrams in 2010, who found for the town in several 1, 2, 3, 4, 5, 6, 7 motions, excepting for the limit of 240,000 or whatever cubic feet of whatever material they were supposed to take. He said, yes, it was unsafe for the town. Yes, I have it at home. I'd love to present it to you at any time. So what happened was, he decided to change his decision. They proceeded on, and then suddenly he said, gee, I made a mistake. I found for the town, but I should have found for WFS. So here's the conditions, and I have 16 pages of his transcript, which I would love for all of you to see. And he said that the Town Planning and Zoning Commission had no business making any laws, and that he was the judge, and he would tell the Town Planning and Zoning to give them a permit. Deal with them and give them a permit. And lawyer Morisuti said even on the part that was not registered for them to be on, because they have been on land that is residential. It never was given to WFS to work on. They've been working on that land for more than 3 years. I have asked time and again for a walk on that site. I would love all of you to come walk on that site. It's been 3 years. It is horrendous. To my knowledge, they've never restored a thing. I don't know, have they, Mr. Lenz?
Nope.
Please, to the...
Well, I'm sorry.
to the ZBA.
I
Thank you.
let them say, but in my opinion, they've never restored a thing. On August 4th, 2010, I went in with a petition to ask the town to please consider the health, safety, and welfare of these people. I don't live right there, but boy, they do. And they get the drift of that silica. Through the night, Mr. Jaboski told me he went out with a dog and shined the flashlight, and this lovely glitter came down. It was just all in the evening, long after they had stopped. These people are breathing this silica dust. We had a good attorney who could have told us what went on with mining in Connecticut. And he was doing a very good job. And he was on the case that Mr. Puska took over from cease and desist of inland wetlands. Somehow that case just mysteriously disappeared. We were able to shut them down because they didn't conform to that restoring that road, fixing the culvert, and restoring the land that they had worked on and now have left it supposedly and going on in progress. This case, to try to find out anything about this case, even going to the selectmen's meeting, you cannot find anything that's going on. It's a big mystery. Go to the town hall, they gave me 4 stacks of papers to go through. I simply wanted to know what happened to the cease and desist with planning and zone, with inland wetlands. I was given 4 stacks of
This is
papers.
not, this is.
I know, but I'm just saying, you
We stay
cannot
on track.
find anything, you can't. It's a mystery as to what's really going on. We need to take a walk on their property so you can see what's happening, to see how endangered the residents are. It's not just, it just doesn't stay on Cedar Lake Road and Turkey Hill Road. It drifts all over. The silica is fine little pieces that can lodge in your lungs, and scar tissue goes over those little pieces and gives you lung damage. Jim Buck died from lung cancer. He lived, has fought this for years, lived behind this wretched operation for years. I think the town must consider the health and safety and welfare of the residents and do what's right. I also want to know how in the world planning and zoning issued a special, this permit when it hasn't even been heard before the appellate court. How did that happen?
Are we respond to that?
No, no.
Okay.
That's P and Z matters.
Okay.
Okay. Anyone else, please?
Alexa Flora, 196 Cedar Lake Road. I'm confused because the language, special exception, I thought it was a special permit, but is it a special exception because they're on the Waller property, they have 33 acres? This permit does not include that property, does it? Because that is strictly residential property.
Jim?
No, I believe it doesn't.
So they are definitely not in any compliance operating on that property.
No.
Permit, they're defined.
Well,
So-
we're just, we're operating under the conditions that were issued by planning and zoning.
But they were never given permission to operate on that former Waller property. And that's 33 acres, and they've been there for years. So what can be done?
Again,
Bring in
that's-
state troopers?
That's not,
and
that's
close
P and Z
the place?
matters, okay? Sorry about that.
Me too.
Anybody else who would like to say something?
Don Jabuski, 31 Sea Lake Road. I have photos for the group tonight. These are pictures that I took on my own of trucks coming in 7:13 in the morning on the Route 9 overpass. Trucks leaving 15:50, which is 10 minutes to 5. These are all, actually, these trucks are on private land, they're not even on the road. These are all timestamp photos. Got tons of, let me know. So when they say they're not sure whether they're in compliance or not, it's pretty obvious that they're not in compliance. There's trucks coming up the hill at 7:32 in the morning. This was taken 2 years ago. All those supposed to be covered. There you go, all covered. Just tracking it out as you please. You guys can look at all these on one. A lot of doubles. Different dates around the same time.
Do you want these issued into, are you going to issue them? Nobody?
Yep.
Yep. And again, they're on private property, they're not even on the road. And also with the plans, I don't know if I have to bring this up now, but Saturday works in the sand pit, well, they're not supposed to be there. They have equipment running those days or Saturdays.
What time is this one?
15:50.
Translate.
10 minutes apart.
10 minutes
Three.
I think.
That's 10 minutes before.
3:50.
Oh, excuse me, 3:50. Right.
10
I'm sorry,
o'clock.
that time is wrong.
Okay.
Okay, and the dust that everybody's concerned about, all these pictures are taken off the state property land, so I'm not in violation of land.
This one.
It's my back lot with the southern with the sand. And here's the land that everybody seems to be talking about, 35 acres that are
Waller property.
uncovered. So literature on silica.
Excuse me, these, just for example, these two pictures here, how close are these to the entrance to the subject property?
Those are coming up by the church, probably a quarter mile. They're on their way to the pit.
Okay, this is, when you say church.
Evaluation?
Yeah.
Down
Oh,
by-
okay, all right.
And what are these for?
That's their Saturday work. The date is Saturday. Let's see what else I got. That's all. This is what the state recommends that they should do with their sand. I could have other ideas. Not be stockpiled. This is back in 2010. The selectmen suggested having a police presence in the area because of speeding trucks violation. That probably recommends bringing the state police into the area.
Is that just a recommendation to bring state police in, or were state police brought in?
State police have been running.
Were any tickets issued? Do we know?
They got radio, so they don't know. This tells how many trucks back in 2009, there were 35 to 50 trucks in the area, which is a violation of their permit.
These are past minutes of October 2009, the P&Z Commission.
Again, this is another letter, September 21st, 2009, same thing with the amount of trucks coming in. Here's a letter from Mr. Gordon, writer to the judge, saying how it was health and safety of residents in the area. Okay.
Thank you. Anyone else?
One other thing before I say that. These, the equipment runs at 7 o'clock in the morning. I don't have to set an alarm clock. They're out there 7 o'clock in the morning running the equipment.
I'm Melissa Schlag. I'm just curious if we can maybe start gathering like information by a cheap time-lapse camera, throw it up in a tree, you'd get the trucks that are uncovered, you'd get a count, you'd have the date, at least gather the information, so in case you need to use it in court, you'd have it instead of being reactive. Could we maybe be proactive in some way?
Again,
I mean-
that's not us, that's That's P and Z, so. that's-
Okay, I will
you can
talk to them.
suggest this for P and Z. Thank you.
Brian Barton, 205 Turkey Hill. I can't say that the trucks are ever uncovered. They do their job and they do that, but my kids are on the bus, they're waiting for the bus at 7:20 in the morning. And the trucks go racing up the road, swerving around. This morning, I counted 6. Toom, 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 toom. They go one after another. I'm not counting time, but I know exactly what time they go by there, and they were up there before. You can hear the screeners and the chainsaws and the wood chipper going at 7 o'clock in the morning. That's when they start. 7 o'clock, boom. Truck 7:30, back and forth, back and forth, back and forth. So there's no compliance there. I mean, it's relentless. That's all.
Thank you.
That's all I've noticed.
Chuck Herman, town resident. Are you aware if there's any noise ordinance that they're breaking as well? Because if they're out there at 7 a.m., I imagine if I was out at 7 a.m., somebody would show up at my house to question me why I'm running a chainsaw.
Excuse me, your name again, please?
Chuck Herman?
Thank you. As far as I'm concerned, we don't have a noise. We don't have a noise ordinance.
So, there's no noise ordinance, and the legal advice that they've gotten so far is to completely ignore all the planning and zoning completely. So, why are we wasting our time? Just have your vote and
Pay attorneys.
pay attorneys, and maybe we should think about getting a better attorney. Seems the one that we have has been with us for a long time and hasn't done a whole lot.
Thank you for your comment.
I have one more thing I want to get to here. It's about a close call with the trucks and the school bus. All 3 trucks went by a stop school bus. I'm sure all these are on file, so should be no surprise to you guys what's in the files.
Thank you. Anyone else?
Yeah, I'd just like to answer a couple of things that people mentioned to you. They have restored some of the area. It's probably maybe 2% or 5% of it. They've attempted to grow grass on the bank. How successful it's been, we'll know when summer comes. Also, the state police did stop at least one person and gave them a warning that was made. So he was speeding. They were very happy, and since I lived on that road, they were very happy to go in and report to the people working in the pit that they had given me a warning. They were nice not to give me a ticket. And the noise, I don't think, generally by permit, they appear to be allowed to use their trucks and their equipment. The idea was to warm it up and get the oil and da-da-da-da-da. But Mr. Barton's right, they certainly run the screener and things like that early. But before 7, they generally aren't working now. But from 7 on, they are.
Thank you very much. Okay, if we don't have any new comments, I'm ready to move to close. Any new comments?
One more comment on the bond. I think that bond is kind of low. Now they have gone forward, you see pictures, you got 35 open acres. You're not gonna cover that with 4 inches of dirt with $80,000.
That's again, a P and Z matter, so, but thank you for your comment.
One more.
Is it new?
No, I was gonna, before he even said that, I forgot, that's what I was gonna say, that the whole covering the material, that $80,000 is gonna go so fast, it's not even funny.
Again, that's a P and Z, okay.
But I'm just saying,
I understand.
they haven't covered anything yet with any material to cover up for.
Thank you.
Why isn't our...
Your name?
Chuck Herman.
Sorry.
His name Chuck Herman, knows her. Why isn't our prestigious legal advice for
our town present?
Good question.
I mean, we're paying him, why isn't he here? I mean, maybe if we didn't pay him, he'd show up, he's gotta show up to get his job.
Thank you for your comment. Okay, we're gonna move on, we're gonna close this hearing. Everybody, can I put a motion on the move forward? All in favor?
Aye.
So move, no more comments from the audience, we'll then discuss it amongst each other. Okay. We know 7 doesn't count, because it's already been issued to us that there is a bond in place. It's 5 and 6 that are the issue, and the fact that P and Z did issue a 6-month special permit, and it obviously was stated that they are not complying because they just don't want to comply to it.
Well, as Jim said, they're supposed to be turning the logs.
Right.
And no logs submitted.
Right.
So,
There's no documentation that they've been.
Yeah.
Well, there's no question. They're not complying because they said they're not.
Right.
It's not like,
There is a permit in place, that's the big thing right here, there is a permit in place. Does everybody agree to that?
Yes, and it's not for us to decide whether
Right.
that permit was granted.
Right.
We are just,
we just
Got-
know that
to
there's
the
a
issues
permit.
at hand.
Yep, exactly. Tom?
I just have this gut feeling that no matter how long the permit would be for, or what the conditions were, they have it in their mind not to comply. And they don't know the first thing about being good neighbors.
Right.
without any record of compliance, physically in hand to see, then I don't see how this will fly. I mean, they're not showing that they're gonna be in compliance, they're proving that they will not comply, so I have my opinion.
Okay, let's talk about the motion here. For voting for this tonight, for holding the cease and desist. If we vote in favor of this, it would hold the cease and desist, that's pretty cut dry, right? I mean, some of them have been kind of, okay, that's what I wanted to make sure. And if you're against it, the cease and desist would be lifted, okay? Everybody understand that?
Say it one more time.
If you vote in favor of this motion, the motion, once I read it, you are gonna hold the cease and desist so that it'll stay in place. If you vote against it, it lifts the cease and desist.
Okay.
Okay. Does anybody have any other comments they would like to make before we read the motion? I'll have somebody read the motion. No? Okay. Here you go, you can read the motion.
I'm in favor of upholding.
Oh, you gotta read the motion.
Okay, make the motion. After hearing the evidence, motion is made to uphold the ZEO cease and desist issued on February 6, 2012 to WFS Earth Materials LLC, attention, Mr. Douglas Anderson, for the property located at 61 Cedar Lake Road, map 52, lot 13-2, on grounds that the appellant is in violation of the special permit issued on January 18, 2012, and the following. Condition number 5, hours of truck operation from 8 a.m. to 4:30 p.m., Monday through Friday, excluding legal holidays. Condition number 6, WFS shall record all truck traffic hauling earth materials from the site on a daily basis and shall be filed with the ZEO on a weekly basis. Such report shall include a copy of the pre-numbered invoice slips for each day, as well as data from the electronic accounting device. Condition number 7, a surety bond in the amount of $80,000 shall be maintained by WFS to assure funds for restoration of the site.
Should we amend this?
Yeah, I was just gonna say
Yeah,
that.
because it was issued in record that number 3 is a no.
Just eliminate the.
No, so,
Sorry, we adjust that.
okay.
Put your point.
put it, crossed out and put issued into record. Of the surety bond, I did not. That was the piece of paper. Yeah. Extended to May 31st. The surety bond is extended to May 31st, 2013. For $80,000. Dated March 2nd, 2012, so it's done. Okay. Okay.
I'm voting in favor of upholding the cease and desist.
Oh, it's me. There's no second.
How did you second that?
I second the motion.
I figured out what was
Yeah.
here.
I'm voting in favor of the cease and desist. In the motion.
In favor of the motion? Okay.
In favor.
I'll also be voting in favor.
Cease and desist is being upheld. We have minutes to go in. Sign now. Sign it. Okay, thank you. Okay. 26? 26. Thank you. She's used to it. She's used to yours. Yeah. We have minutes to go through.
You're done? Yeah.
Thank you.
Thank you. Did everybody look at the minutes that came in on email, the fact that we had some canceled meetings and any corrections? Yeah.